Good morning, everyone. Are we ready?
Morning.
Yes, Your Honor.
Yes, Your Honor, the state does.
All right. Looks like we have one interpreter matter. Noveen Juarez.
Sí, llamando a Novin Juárez.
What does the state feels appropriate on this matter?
¿Qué cree la fiscalía que es apropiado en esta causa?
Yes, Your Honor, in this case, we are asking for $10,000 bail.
Sí, su señoría, en esta causa estamos pidiendo $10,000 de fianza.
No contact with the victim, Jocelyn Juarez,
No tener ningún tipo de contacto con la víctima, Jocelyn Juárez.
and no weapons.
No portar armas.
In this case, the defendant scores a 5.
En este caso, el puntaje del imputado salió un número 5.
He had an arrest for domestic battery in 2002 in Oakland that was dismissed.
Tuvo un caso en Oakland en el 2002 por violencia intrafamiliar que fue sobreseído.
He also had an arrest in 2025 in Oakland for CCW that looks like it was also dismissed.
También tuvo otro caso en I'm so sorry, Mr. DA, the interpreter didn't hear the year.
2025.
También tuvo un arresto en el 2025 por llevar un arma sin tener permiso, diciembre, que fue sobreseído.
In the state's view, bail is necessary because the defendant does not have any contacts with Northern Nevada.
Y creemos que la fianza es necesaria porque no tiene ningún tipo de contacto aquí en el norte de Nevada.
It appears that he lives somewhere in California, possibly Oakland.
Y que parece ser de que él vive en algún lugar de California, posiblemente Oakland.
We have continued the hearing for victim contact, but unfortunately have not heard back from the victim.
Habíamos aplazado la audiencia para poder tener contacto con la víctima y desafortunadamente no la hemos podido contactar.
And so therefore, at the present time, we're asking for the no contact order based on the facts of the case.
Basándose los hechos del caso, por lo tanto, entonces pedimos que no haya ningún tipo de contacto con la presunta víctima de este caso.
And with that, we would submit it, Your Honor.
Con eso lo dejamos a su criterio, su señoría.
All right, thank you. Defense.
Thank you, Your Honor. In this case, we are asking for an OR release. The highest charge here is a gross misdemeanor, and as the state indicated, this individual has absolutely no criminal history, 2 arrests with no convictions. So we have no reason to believe he would fail to appear for his hearings here. He does live in Oakland. We were able to contact his reference, his daughter, Patricia. Patricia did indicate to us that he has lived in Oakland for 25 years.
And Ms. Greggio,
Yes.
Madam Interpreter may.
Oh, I apologize. I apologize.
Thank you. Bueno, su señoría, nosotros lo que vamos a pedir es una orden de que usted que lo dejen salir al imputado bajo palabra de honor. En este cargo es un delito menor agravado. El imputado no tiene antecedentes penales, tenido 2 arrestos, pero ninguno de ellos ha tenido su condena. Creemos que él sí va a comparecer. Él acá vive en Oakland. Nosotros pudimos contactarnos con la hija Patricia y ella dijo de que han vivido aquí en el área por 25 años.
Furthermore, Your Honor, we believe he is not a risk to the community for the lack of criminal history at 48 years old.
Por lo tanto, creemos, su señoría, de que él no es un riesgo aquí para la comunidad. Él tiene 48 años de edad.
As I stated, we did verify his residence through his daughter.
Como dije, verificamos su domicilio a través de su hija.
He lives at 1926 104th Avenue in Oakland.
Él vive en la 1926 104 Avenida en Oakland.
And so that, although that that address doesn't bring his score down because it is not in Nevada. He's still at a 5, a moderate risk.
Y aunque eso, él no baja su puntaje por él no ser residente de Nevada, creemos que él es un riesgo moderado.
And Patricia did verify his phone number, so that would bring us down to a 4 on the NPRA.
Y él sí, Patricia nos confirmó un número de teléfono y eso bajaría su puntaje a un número 4 en la evaluación previa al riesgo de Nevada.
And with that, Your Honor, I will submit.
Y con eso, su señoría, lo dejo a su criterio.
I believe I am required to release the defendant on his own recognizance.
Creo que es requisito de que lo deje salir bajo palabra de honor.
No contact with the victim.
No puede tener contacto con la víctima para nada.
Separate criminal offense for 120 days pursuant to statute.
Por este delito penal son 120 días de cárcel de acuerdo a la ley.
Washoe County Pretrial Services Supervision.
Tiene que tener supervisión con el condado de Washoe.
Next court date, January 9th at 10 a.m.
Su próxima comparecencia será para el 9 de enero a las 10 de la mañana.
What can we do? Oh, is that okay? Sorry, it'll be January 12th.
Perdón, es el 12 de enero.
Thank you.
Gracias.
Si vives con Jocelyn, no puedes vivir con ella, okay?
That's all the interpreter matters we have. Well, let's double check with the jail. Anyone else up at the jail need an interpreter?
¿Alguien más necesita intérprete?
I believe not, Your Honor.
Thank you very
All right,
much.
thank you. Have a good day. Amanda Alito and then Brian Trotter.
Last name? Alito. Your Honor, may I have a moment?
Of course.
You're gonna get this. You are, yes. That's funny. I don't think they heard. You're ready.
Oh, sorry, Your Honor. The defense is ready. I apologize.
All right, what does the state feels appropriate?
Yes, Your Honor. With Miss Alito, we're asking for $5,000 bail, supervision to check in, as well as no contact with the Cal NEBA. The defendant scores a 5, has no real ties to the community, appears just in town for staying at the hotel. I show that she has an arrest in 2024 for willful cruelty to a child. That appears that she was given diversion in that case, and that was in Chico, California. And so, again, no apparent contacts to the community. Has a recent case where she availed herself of diversion, but obviously speaks to some underlying issues here. And so based upon the lack of ties to the community and therefore the lack of, or the risk of non-appearance, as well as the violence here after having the 2024 diversion case on a willful cruelty to children, we believe she's a risk for continued conduct as well, and believe that the bail supervision and to make sure that if she does bail out, she stays in contact, and the no contact with the Cal NEBA are appropriate. Thank you.
All right, defense.
Thank you, Your Honor. In this case, Ms. Alito has indicated that she is not currently working, and so she is unable to afford any amount of monetary bail. Similar to the last case, Your Honor, she has the prior case that the state talked about where she received diversion. So presumably There is no conviction on that case. The highest charge in this case, similarly like the last case, is a gross misdemeanor. Although she lives out of state, she does live with her children there, and so again, Your Honor, we were unable to reach her reference in this case. However, we do believe that simply being an out-of-state resident doesn't make her a flight risk or unable to appear for court hearings. And so we would ask for an OR in this case.
All right. Because the defendant's low risk, I believe I'm required to release her on her own recognizance, no contact. Washington County Pretrial Services Supervision, or bail laws make all court appearances January 13th at 9:30 for the defendant's next court date. See that? Trotter and then Cloninger.
Yeah, Trotter first. Okay, Mr. Trotter.
All right, let's speak with the program on this matter.
Yes, Your Honor, and so I would note we'd reach out to the victim. She indicates that she was going to be trying to watch this through YouTube, that she is pregnant with the defendant's child, and so she does not want a no contact order, so she's not in fear for her safety. So as far as the no contact order, I would submit it on the wishes of the victim. However, in this case, we are asking for bail, and we are asking for $5,000 bail. Concerning in this case is obviously that this he was arrested as a second offense. His harassment conviction was in a Sparks Justice Court case in 2025 that occurred on November 2nd, 2025, and he was convicted November 20th. So clearly concerning given that was just a couple months ago. Also had a obstructing conviction in Sparks Municipal Court in 2025. Then he has a gap in his history. His history goes back to 1984, but he prior to those two cases here in 2025, I show he had a felony conviction for purchase cocaine in 2010 in California, a felony conviction for possession or purchase cocaine in California in 2003, a felony conviction for threat and crime with intent to terrorize in California in 2003. He was sent to prison on both those cases. And then felony controlled substance convictions in California in 1998 and 1986, and in 1984 felony conviction for burglary. Again, concerning criminal history, although a lot of it is fairly remote, concerning in that whatever's going on in the last year or so in the defendant's life appears to be not resolving, and therefore, based upon that, we believe he's a risk to the community, risk to continued conduct. When I looked at that other harassment case, it was multiple charges against multiple victims, not including this victim, and it was resolved as one charge. But again, concerning given what happened here and the fact that the defendant made these statements to the victim in full view of law enforcement. So clearly not dissuaded by the fact that officers were there when this was going on. And so, again, I submitted as to the no contact order with the victim based on her statements, but we do believe he's a risk to the community and the rest of this victim, frankly, and that bail and supervision as well as no weapons would be appropriate. Thank you.
Thank you, defense.
Thank you, Your Honor. In this case, we are asking for an OR release, Your Honor. Based on the facts of this case, it's interesting to me that it was charged as harassment. To me, these appear to just be simple assaults, misdemeanor assaults. It all happened in one distinct instance. It wasn't like a pattern of behavior over an extended time. Obviously, the wife stated that it was a verbal argument. There was nothing physical or violent, other than some of the things that this individual said. The felonies are all very remote in time. Yes, they go back to the 80s and 90s, but in the last decade or more, this individual has had very minimal criminal history, as the state indicated. Really, the harassment and the ONR, the resisting case last year. And so we were unfortunately unable to verify his personal information. But if there is if a no contact order is not imposed, he would return to where he was living with his wife. He also can go to an alternate address if a no contact order is imposed. He indicated that he can go to 147 Ralston Street. He does indicate that he works for a trucking company. And so he's been in our area for 4 years. He has an expecting wife, definite ties to the community. In his recent cases, there were no failures to appear. And again, the highest charge here is a gross misdemeanor. And so I would argue that this individual can be adequately supervised and will appear to his to court and does not pose an ongoing risk given that very minor recent criminal history.
Well, I as well have read the probable cause sheet in the Sparks case. I agree with the state, very concerning behavior. The defendant then pleads and receives a 60-day jail sentence. He must have just recently been released on that. He had 12 days time served at the time of his plea, and now he's engaging in similar threatened behavior. I don't know what's going on either, but because I don't know what's going on, I have no ability to minimize the risk that he poses to the community and stop him from making good on all of these threats that he keeps doing in our community to individuals. And that prior case involved allegations of threatening people with a knife, threatening people with other objects. Now he's threatening to basically end the life of this baby. The bail be set at $25,000 because the state shown by convincing evidence that bail, even outside the defense ability to make it, is necessary to ensure the safety of the community and the appearance of the defendant. No contact with the victim. Washington County Pretrial Services Supervision of bail laws make court appearances. We'll see you back this Friday the 9th at 9:30. Thank you. Cloninger and then Campbell.
Your Honor, Mr. Campbell, we are asking for a continuance until tomorrow.
All right, is Cloninger up there? All right, Campbell, we'll see tomorrow. What does state feel is appropriate on Cloninger?
Yes, Your Honor, Ms. Cloninger, we're asking for $3,000 bail, supervision and testing. The defendant, as noted in the probable cause, has a warrant from El Dorado County. She also had a failure to appear in 2018 here in Reno. Her history, so she's got a 2001, appears to be a misdemeanor conviction for wet reckless in Humboldt County, California, and then a 2005 felony conviction for possession of a controlled substance in Humboldt that looks like it was reduced to a misdemeanor after 10 years in 2015. It appears some ties, apparently given the failure to appear arrest in 2018, I couldn't tell what was underlying that charge here in Reno, but again, concerning given that she's got the out-of-state warrant that she will not appear, and clearly controlled substances have been an issue for quite some time in her life. And obviously fentanyl is a very concerning substance and has 4 gross grams and then the 7 gross grams weight that were found on her person at the jail, a somewhat larger amount, although it's still possession of a controlled substance. So taking all that into consideration, we believe that bail and supervision and testing are appropriate. Thank you.
Defense?
Thank you, Your Honor. In this case, the defendant scores a moderate, a 6. Unfortunately, we were not able to reach her reference. However, she did provide us with an address. She states she's been here in Washoe County for at least 10 years. As Your Honor can tell, this defendant has had some health issues. She was continued yesterday due to her health issues. And so we would ask for an OR. We would ask with direct transport to inpatient if, given the nature of the charge, the fact that it's a diversion mandatory charge, and given this client's health issues at the moment.
All right. Based on the risk score, I am required to release her on her own recognizance. Bail laws make all court appearances January 13th. At 9:30 is your next court date, Washington County Pretrial Services. Ona? And then Neil?
So for Aunu Robinson, we would ask to set interim bail.
All right, why?
He refused coming to court today, Your Honor. Or we could continue it till tomorrow.
This is the first or second refusal.
It's the first because it was a once check yesterday.
All right, sounds like it's first refusal. We'll see him tomorrow. Neil and then Hodges.
Neil? Oh, she also refused, Your Honor.
First refusal.
Your Honor, I believe, well, it was noted that she was ill yesterday.
Second.
All right, let's go ahead and go forward then. What is the state feels appropriate?
Yes, Your Honor, in this case, we're asking for $5,000 bail, pretrial supervision and testing. The defendant has a criminal history going back to 2009, primarily substance abuse related issues. She had a minor in possession and open container in that 2009 misdemeanor conviction here in this court. Most recently, she had a citation for possession of drug paraphernalia and drinking in public in Reno Municipal Court. I believe that's the warrant she was noted when contacted, where she had failed to appear on that. She had a misdemeanor conviction for possession of drug paraphernalia in Sparks Justice Court in 25, had another failure to appear arrest, and then a misdemeanor conviction for battery in Reno Municipal Court. Then in 2024, she had an arrest for contempt, misdemeanor conviction for resisting, misdemeanor conviction for battery. Those are both Reno Municipal Court. Had another failure to appear arrest, misdemeanor contempt, and trespass in Carson conviction. Misdemeanor conviction for obstructing and resisting, as well as conviction for failure to appear in Reno Municipal Court. Going back, has some minor property issues. Had one arrest in California in 2014 with no disposition, but otherwise trespass and contempt type arrests going back to that 2009. So believe she's a risk not to appear, risk to continue that conduct, and given the recent issues, believe that bail and supervision are appropriate. Thank you.
Okay, that's
So, Your Honor, we did not have the opportunity to interview Ms. Neal. So with that, I would ask that Your Honor set the bail as interim bail, and I will submit since I have no information to present.
all right. Thank you. Given the defendant's risk score, the state shown by clear and convincing evidence entered from that's great. That bail outside the defendant's ability to make it is necessary to ensure the safety of the community. The appearance of the defendant was set at $20,000. The bail laws make all court appearances. Washington County Pretrial Services supervision, January 9th at 9:30 is the defendant's next court date.
The intern?
No.
No.
Hodges. And then Arvayo after Hodges. All right, what does state feel appropriate on this matter?
Yes, Your Honor. So, and we spoke with the victim in this case, Janitzi Gonzalez. She indicated that she would like a no contact order. That the defendant had been texting her during the holidays. And so we are asking for a no contact order with her pursuant to NRS 178, such that it's a new and subsequent offense. I believe that she may be watching via YouTube link here today. Did not want to make a statement as far as I can tell with our notes. In this case, we and I apologize that my notes were poor yesterday as far as whether or not we arraigned the defendant, but again, he's charged with the domestic battery by strangulation, the category C. We are asking for $10,000 bail, as well as supervision, no weapons, and the no contact. With the my notes from yesterday, Adulia PD was appointed just for purposes of today's hearing only, as he didn't qualify for the public defender otherwise. And so with that, I would submit it, Your Honor.
All right, that's
Thank you, Your Honor. In this case, we are asking for a amount of bail that this individual can afford, which is the amount of $500. He scores a 3, which is extremely low on the NPRA, and that is in large part because he has absolutely no criminal history. We were also able to verify his residence, and so that would bring him actually down to a 1. He does live in Fernley. He is active in the Navy, and we were able to contact his supervisor, who indicated that he does live in Fernley at 1240 West Newlands Drive, number 2. Again, he is an active service member and has been for 8.5 years. His supervisor indicated that if he's unable to stay at his address, the Navy will provide him with a room on base through the Navy Lodge. He also indicated that this individual is an extremely hard worker and has never had any problems in his service in the Navy. And so he also verified his phone number. So again, Your Honor, although the charges are serious, we believe that a small amount of monetary bail would be sufficient to protect the community. Again, he has ties to the community. He is not a flight risk, given his employment and his residence in Fernley. And so there are also other adequate ways to protect the community, such as a no contact order, supervision through, I believe this would be now pretrial services. And so, Your Honor, with that, we ask for $500 cash bail and the conditions suggested by the defense.
I don't believe there is effective supervision anymore with regards to situations like this. The only, since pretrial services is now law enforcement, the only recourse they have is to send a violation to the court when an individual violates the conditions, meaning threatens or contacts or harms the victim. And then the most that a court can do with or without a hearing is to issue a warrant. And so when we had DAS, individuals could respond immediately. They're on call 24 hours a day to any threatening situation, but that is no longer the case. And without that, in this case, based on the facts and circumstances as reviewed by the original judge and by me, the bail as originally said is appropriate. next court date. We haven't arraigned the defendant, and I don't think that's on the list of things that the sheriff wants to do on weekends. And so we'll arraign him Monday.
All right, thank you, Your Honor.
100,000. Yeah, you can talk to Mr. Morello.
Arvayo and then Whitlock. What is the state feels appropriate on this matter?
And this is Lazaro.
Correct?
Are we okay? Thank you. Yes, Your Honor. So with Mr. Arroyo, we are asking for $5,000 bail, no contact with the Grand Sierra Resort, and pretrial supervision. The defendant does not appear to have very much in the way of contacts for Nevada. So he does have an arrest in Humboldt County in 2025 for DUI that I don't show a disposition for. It appears that case may still be pending. It appears that from the information I saw, so he had the Utah license, and there was some reference to California employment on the NPRA. So it appears that he does not have much in the way of contacts with this area. And given that recent DUI arrest, unclear exactly what prompted him to have the issues with Remza in this case. But given that substance issue already earlier this year, it appears that he is making some poor decisions of late, and therefore we believe that bail is appropriate to ensure that he is not a risk to the community, not reoffending. And given the fact that he's got no local ties, that he appears in the future. With that, I'd submit it.
Thank you. Defense?
Thank you, Your Honor. So, Your Honor, in this case, we were able to verify this individual's residence. We contacted his sister, Jasmine Lopez, and she did indicate to us that he has lived in Winnemucca his entire life, and he currently lives at 4200 Maslona Drive, number 99, with his sister, Jasmine. She did confirm that he is employed. He is a store manager with Verizon. He's been there for 2 years. And so he does have ties to the community, albeit in a different county in I believe that's Humboldt County. As the state pointed out, I think it's very important here that we have absolutely no details on the circumstances of why Remsa was called. So we don't know that his actions were willful. We don't know if he was having a mental health episode or if there was substances involved. With that, Your Honor, with his lack of criminal history, certainly there's an arrest for DUI without a disposition. And again, this is a case where the highest charge is a gross misdemeanor. Without knowing more about those circumstances, it's hard to say that he is a risk to the community. And with his ties, he's definitely not a flight risk. Even though he had the arrest for DUI, there's no indication he ever failed to appear. And so with that, Your Honor, I do believe that an OR release is adequate and appropriate and will ensure this individual shows up to court and protects the community from whatever happened here, which doesn't seem to be indicative of any kind of pattern.
I believe I'm required to release the defendant on his own recognizance, obey all laws, make all court appearances, no contact with business, Washington County Pretrial Services Supervision, January 13th, 9 a.m. to the defendant's next court date.
You'll have to come back for court dates, okay?
Whitlock and then Pollock. The state feels appropriate on this matter.
Yes, Your Honor. So in this case, I would note we spoke with Brandon Whitlock. He indicated that he would be watching online. He said he does not want a no contact order and he is not in fear for his life, and this was an isolated incident. Given that and the lack of criminal history, not understand this is a serious charge in the ADW, but given the um, details there and the no history and the wishes of the victim, I'm not objecting to an OR. I do believe a no weapons clause would be appropriate as well as obey all laws and supervision to make sure she's checking in. Thank you.
Any objection?
No objection, Your Honor.
All right, so ordered January 13th, 9:30 is the next court date.
Thank you.
Pollock and then Fike. What does the state feels appropriate on this one?
Yes, Your Honor. So I would note that we continue this for victim contact. We unfortunately were unable to hear back from the victim. However, given the allegations here, we are asking for $20,000 bail, no contact with the victim pursuant to NRS 178, such as the new and subsequent offense, no weapons, and supervision and testing for alcohol and controlled substances. The defendant has criminal history going back to 2020. He had a misdemeanor conviction for DUI in that year. Then he had a 2023 case where he had a battery on a protected person case that was dismissed upon completion of youth offender court. He had a misdemeanor conviction for DUI second here in the Reno Justice Court, which I believe he still has a suspended sentence on. Again, concerning given the allegations here, and it appears from the dollar amount that the victim indicated that he had extorted from him, that this has been going on for a period of time. And that there was also a decent amount of damage done at this time. And again, according to the victim, this stems from drug abuse. So we believe that in order to ensure that the defendant appears and complies, and for the protection of this victim and the safety of the community in general, given the fact that he's got now multiple substance abuse related convictions, that the bail as well as conditions are appropriate. With that, it's submitted.
All right, thank you. Defense?
Thank you, Your Honor. In this case, we are asking for an OR release. The client's prior participation in youth offender court would indicate substance abuse issues as well as mental health issues. And so certainly we would ask that if he is OR'd, that if Your Honor orders him to be transported directly into treatment, that would be appropriate, given his history, given the charges here. Mr. Pollock did indicate that he does have an alternate place to stay with friends. Unfortunately, we attempted to reach some of his one of his contacts, but we were unable to. Unfortunately, he didn't have a lot of phone numbers that he was able to get from his phone when he was admitted here to the jail. And so, however, he does indicate that he's been looking for work as an electrician, and again, that he has an alternate place to stay. He is 28 years old. He's been here his whole life. And so we do think that an OR with conditions would be adequate to mitigate any risks to the community. Conditions such as testing and supervision.
All right. On the most recent case with our court, he was convicted of in September, the end of September. He received a 180-day suspended sentence in that case, had many conditions, including treatment. And an order to show cause has already been set because he failed to provide any proof of treatment. So I don't believe ordering to do treatment will minimize the risk that he poses to the community. I'm going to move up the order to show cause that's currently set for February 3rd in that case to this Tuesday, the 6th at 8:30, given the seriousness of these new violations. Based upon the state's presentation, I do find by clear and convincing evidence that bail outside the defendant's ability to make it is necessary to ensure the safety of the community and appearance of the defendant will be set at $50,000. That's 50. No contact, separate criminal offense pursuant to NRS 178-4845 for the maximum 120 days. Random drug and alcohol testing, no firearm. Checking with Washoe County Pretrial Services as ordered. Next, bail laws make all court appearances. January 9th and 9/30 is the defendant's next court date. We'll see you back then. Pike, and then Anderson.
This is Mr. Fike's second refusal, Your Honor.
All right, what does the state feels appropriate?
Yes, Your Honor. In this case, we are asking for $50,000, bondable only bail, supervision, and no weapons, no contact with Diamonds Casino or the victim. In this case, Your Honor, the defendant's scores of 12, criminal history going back to 2007, had a couple possession of drug paraphernalia cases with no disposition, one in 2007, one in 2009. 16 had a trespass conviction in Reno Municipal Court. 2018 had a misdemeanor conviction for battery and resisting in Sparks Justice Court, as well as a misdemeanor conviction for drawing a deadly weapon in a threatening manner in Elko Justice, obviously concerning given the facts here. 2019 had a misdemeanor conviction for domestic battery and destruction of property in Sparks Justice Court. 23 had a misdemeanor conviction for theft in Tahoe Township, as well as a misdemeanor conviction for trespass here in Reno Municipal Court. 2024 had a misdemeanor conviction for trespass in Reno Municipal Court, as well as a failure to appear arrest in Douglas County. Had an arrest in Carson in 25 for obstructing that I don't show a disposition for, as well as another failure to appear arrest in Douglas in 25. So clearly concerning conduct, given this started with a trespass at Diamonds, led to the stabbing out at the bus stop with an individual who has trespass and prior violence convictions as well. And so we believe that all those conditions are appropriate based upon the risk of the community, as well as risk not to appear given his multiple failure to appear arrests recently in this jurisdiction and in Douglas County. Thank you.
That's
Your Honor, since we were unable to interview Mr. Fike today, I would ask that Your Honor sets interim bail, and I will submit since I have no information to provide.
all right. State shown by clear and convincing evidence that bail outside the defendant's ability to make this necessary to ensure the safety of the community and appearance of the defendant will be set as requested. No contact with the individual victim and the business. The individual victim will also have an NRS 178-4045 separate criminal offense for 120 days. No firearms. Checking with Washoe County Pretrial Services as order of bail laws, make a court appearances January 9th at 9:30 a.m. is defendant's next court date. And because of the defendant's refusal to participate, this is not an interim bail.
And Your Honor, I apologize for Madam Court Clerk. I think I forgot to mention the victim's name of Marco Villa. Thank you.
All right, thank you. Anderson and then Kurashewicz. All right, what does the state feels appropriate on this, man?
Yes, Your Honor. So I would note that we spoke with the victim, Mr. Juan Flores. He is requesting a no contact order. He indicates that his concern is because there have been prior incidents involving the children in this case. And so we would ask for no contact with Mr. Flores, as well as the East Shore Place. I note that the defendant does not have any prior criminal history. And so based upon that, I don't have an objection to her OR, just with the conditions that she had not have contact with the defendant. I'm unclear if there's CPS involvement or HHS involvement at this time. So we would also ask for supervision and comply with any sort of HHS or CPS type orders and no weapons given the allegations of violence here. Thank you.
That's,
No objections, Your Honor.
all right, that'll be the order. Next court date, January 13th. At 9:30 a.m. Karashwitz and then Lee. I would state what's appropriate on this matter.
Yes, Your Honor. In this case, we're asking for $5,000 bail. The defendant has some recent criminal history concerning in that in 2023, she had a felony conviction for battery with a deadly weapon. She also had a failure to appear arrest in that year. She had a trespass and obstructing in 2025 that I don't show a disposition for in Reno Municipal Court. And then she was arrested for that failure to appear on that Reno Municipal Court case at the same time as this. And so, frankly, given that felony conviction 2 years ago, as well as the failure to appear, we believe that bail is appropriate. We would also ask for no contact with the victim, and I apologize, I did not note her name in it was Robin Karashewicz. Sorry for butchering that name, but no contact with Robin as well. Thank you.
That's
Thank you, Your Honor. In this case, we are asking for an OR release as this defendant cannot afford any amount of monetary bail. She does score a higher on the NPRA. Interestingly, she has no prior misdemeanors in the last 10 years. She has only that conviction for the battery with a deadly weapon in 2023. She indicates that she is pregnant, and if she is released, she would go get prenatal care. She did indicate that she has a place to stay with her boyfriend. We were able to contact him. He confirmed that this defendant can live with him at 2200 DeAndrea Parkway. He confirmed that she does work at Mountain Mike's and has been there for about a month. And so she did get points for no address and for no employment. So that would bring her score down slightly. The criminal history indicates no prior substance abuse issues. And so again, with a confirmed address, place to stay, and with adequate conditions such as checking in, we do believe that an OR is appropriate. Again, this was charged as a gross misdemeanor. And the charge is that she grabbed her mother's cell phone and threw it. So certainly not a felony charge. So again, Your Honor, with that, we ask for an OR release with conditions.
all right, I'll give her a chance. OR, no contact, separate criminal offense pursuant to NRS 178-4845, obey all laws, make all court appearances. No firearms because the prior January 13th at 9 a.m. is the next court date. See that. Check in with Washington County Pretrial Services as ordered. Lee?
Is that a refusal?
Oh, it's not here yet.
After Lee is Mackenzie.
I think, let me see. One moment, Your Honor, please. Court's indulgence. Oh, Mr. Lee wasn't feeling well and asked if we can continue his case till tomorrow.
All right. Mackenzie. And then after Mackenzie is Steptoe. What state feels appropriate on Mackenzie?
Mr. Honor, regards to Ms. McKenzie, we were asking for $5,000 bail. Defendant scores fairly high on the MPRA. Has criminal history go back to 2021. That year, she had a misdemeanor conviction for reckless that was down from a DUI. She had a possession of drug paraphernalia conviction, an obstructing conviction, as well as a trespass conviction. 2022, she had a trespass conviction, a resisting conviction, a couple of arrests for violating probation or suspended sentences on those cases. 2023, she had a misdemeanor conviction for tampering with a motor vehicle, had a failure to appear arrest, had a possession of controlled substance arrest with no disposition, also had an obstructing and trespass conviction. And then in 2025, she had a battery case that was down from domestic battery and Sparks Justice Court, a conviction there, and as well as a possession of drug paraphernalia conviction in this court. So in the state's view, a risk not to appear given the recent failure to appear as in 2023, as well as clearly substances are at issue for her, and she continues to engage in that conduct and be near a place with where drug activity is going in Diamonds Casino. And so we believe that bail and supervision and testing are appropriate and would ask you to impose that. Thank you.
All right, defense.
Thank you, Your Honor. In this case, this defendant cannot afford any amount of monetary bail, so we are asking for an OR release. She does have a verified phone, which means she's able to check in and be supervised. While her history is concerning, this is a felony diversionary case and a paraphernalia misdemeanor. I don't see any prior felonies in her criminal history. I don't see any violence in her criminal history. Really, it looks like a case of her criminal history seems tied to substance abuse. And so an OR release is appropriate. There are adequate conditions to ensure her appearance and safety of the community. She could be released into a treatment facility, and supervision and testing can be imposed to ensure she remains compliant.
Well, I have tried to help Cameo before. I'd certainly be willing to try again. We can't say she doesn't have any violence because she's got a warrant for a battery case at a Sparks Justice Court. I have no doubt that treatment is the appropriate response. I will release her to treatment at the level that an evaluation supports. Until then, her bail's $10,000. Random drug and alcohol testing, all bail laws, make no court appearances. So see you next Friday at Cameo at 9:30. Step toe. After step toe is Adams. All right, what the state feels appropriate on Mr. Steptoe.
Yes, Your Honor, we're asking for $5,000 bail as well as supervision. The defendant appears to have only been in the area staying at this hotel, the Calneva. So lack of contacts to the community, but given this occurred at Calneva, we're also asking for no contact with the Calneva. Again, this is co-defendant to Miss Alito earlier this morning, and it appears they live in California. Note this defendant appears to have been more involved in the violence than Miss Alito. He has a criminal history going back to 2012. He had a misdemeanor conviction for disorderly conduct, being intoxicated in Lake County, California. And then he had a misdemeanor conviction for driving a license suspended in Ukiah in 2019 is what I show for his criminal history. But given the lack of ties to the community, the violence here, we believe that bail is appropriate and ask that you impose it. Thank you.
All right, that's
Your Honor, I'm going to be asking for an OR release today. The co-defendant got an OR release due to the same exact charges. And looking at his criminal history, he has absolutely no failure to appear, no felonies, and no crimes of violence, and there's no pending case right now. Looking at that, there's nothing that the court has in front of him showing that he will fail to appear, even though he does have lack of ties to his community because he was visiting. So Your Honor, given all of that, I think he should be given the OR release. He also does have he is extremely employable. He is a therapeutic skills coach, and he has been doing that for the past 2 years. He's unemployed right now, but he is currently looking for work, but that's something he will find a job at because it's a very tailored skill. With that, Your Honor, I think he should be given the OR release with supervision and a no contact order with the CalNEVA I feel is entirely appropriate, and I will submit on that.
All right, given the defendant's risk score, I think I am required to release him on his own recognizance, no contact with the CalNEVA. Supervision with Washington County Pretrial Services obey laws, make all court appearances January 13th, 9 a.m. is next court date for his arraignment. Thank you. Adams. And after Adams is Ayano Sumatai. The state feels appropriate on this matter.
Yes, Your Honor. So with Mr. Adams, we are asking for $75,000 bondable only, supervision, some sort of daily testing, preferably by Scram, no possession or use of alcohol and controlled substances, as well as no driving unless properly licensed. So the defendant appears to have had issues with alcohol for quite some time. He had his first conviction as a minor consuming alcohol or possessing alcohol in Redmond, Washington in 1994. Had a misdemeanor conviction in 98 for DUI and driving while license revoked in Redmond, Washington in 1998 again, sorry. 2006, he had a misdemeanor arrest for DUI 0.15 or more in Phoenix, Arizona that looks like it was ultimately dismissed. 2008, he had a misdemeanor conviction for DUI in King County, Washington. Then in 2011, had a misdemeanor conviction for DUI in Issaquah, Washington. He appears to have come to our area sometime in 2013. He was convicted of a DUI third here in the second judicial in 2014. Then he was convicted of a DUI with a prior felony here in the second judicial, a case that arose in 2019, and he was convicted in 2022. And here we have obviously concerning, given that he was intoxicated and ran himself off the road, having not one but two prior felonies for DUI and obviously multiple DUI convictions and arrests in his past. So therefore, we believe that the defendant is a risk to the community that can continue to commit these actions and believe that bail and conditions are appropriate. Thank you.
Thank you. Defense.
Thank you, Your Honor. In this case, this individual, Mr. Adams, is facing some very serious charges. So we do believe some amount of monetary bail is adequate. We would ask for $50,000 bondable or with a 10% cash option. Obviously, the nature of the crime and his criminal history would require him to be supervised. OSM Scram device, for daily testing would be appropriate in a case like this. He does score a 7, which is a moderate. He doesn't have any other pending cases. He doesn't have prior misdemeanors in the last 10 years, of course. He does have a serious history with drinking and driving. There are no violent convictions. He really doesn't have any prior failures to appear, even though he has faced serious charges in the past. And so, again, some amount of monetary bail is adequate. We would ask for something he can afford. Additionally, Mr. Adams has strong ties to the community. He indicates he's been in our community for 13 years. He does own a home here in our community that he has lived at for the last 5 years. Unfortunately, we were unable to reach his reference, but he also indicates that He works as a chef and has done that for the last year or so. And with that, Your Honor, I will submit.
Okay, thank you. Standard risk tools like the NPRA are not valid for impaired driving cases. That's why EAS did the DUI rant for us on all our cases. I certainly hope Washington Pretrial Services starts doing that. We don't need a DUI rant, though, to tell us the grave danger this individual poses to the community. If you're going to be killed by a stranger in our country, it's most likely by an impaired driver. And this defendant poses a great risk in our community to do so. Therefore, the state shown by clear and convincing evidence that bail is necessary to ensure the safety and community appearance of the defendant. We said at $100,000. There's always a 10% option in all of my cases because that's the best practices. Residential confinement in place before release. I'm doing that because that's a requirement of our felony DUI court. I assume some research went into the effectiveness of that. Random drug testing, daily alcohol testing, check-ins with Washington County Pretrial Services as required. Bail laws make a court appearances January 9th at 9 a.m. So the federal sex court date was even back then.
So that was the 13th, Your Honor, for the.
No, the 9th. In custodies are the 9th, out of custodies are the 13th. Iono Sumatai, and then Bill. All right, what's the state feels appropriate on this one?
Yes, Your Honor. In this case, we are asking for $25,000 bondable bail, supervision, and no weapons. So the defendant's criminal history goes back to 2017, had a misdemeanor conviction for taking a vehicle without consent in that year. His prior felony, concerningly for this case, occurred in 2020. He was convicted of CCW in a vehicle and carry loaded firearm. That was in Santa Clara. It occurred in 2019, but he was convicted in 2020. Those are the, he had some other arrests in there, so unsure if it was issues with complying with supervision, but those are the convictions that show all the arrests appear to be related to those charges. Again, most of his history is out of California, although I understand that he lives here with his, or was living here at that McLeod address. However, given the issues there, we believe that he is a risk to the community, risk not to appear in the future given the serious charges here, and that bail is appropriate. Thank you.
That's
Thank you, Your Honor. In this case, we are seeking an OR release as this defendant cannot afford any amount of monetary bail. We were able to verify his residence. He does live with his parents, as was stated in the probable cause sheet, and we were able to contact his mother, Saili, and she confirmed that he still lives there, is welcome to return, and that he lives there with his parents and his siblings. He's been there for the past 3 years. He's been here in our community for the last 10 years. She also did confirm that this defendant is employed. He works at Renown. He does janitorial work. He's expected back there, for his regular. Tonight at 11, he indicates to me, would be his next shift at work. So with that verification, Your Honor, that would lower his NPRA score to a 4, which would be a low. Although he does have prior firearm cases, there's no history of using those firearms, so no history of violence with firearms. There appears to be no substance abuse issues. We see no failures to appear. And so we do believe that an OR is appropriate in this case. This individual has a residence, has a phone, has a job. He's able to be supervised. And although serious, the crimes that he's facing are probationable. And so with that, Your Honor, we would ask for an OR release with conditions, of course, No firearms, no weapons, and checking in with pretrial supervision.
All right, because these stores are low risk and there's no recent crimes of violence, I'll release money on the recognizance, no firearms, checking with Washington County Pretrial Services, order to bail laws, make no court appearance to January 9th at 9:30. Is the defendant's next court date? Thank you.
It's your next court date. You're gonna be released.
So, Your Honor, so if he's released, that would be the 13th, correct?
Yes, you're correct. Thank you for touching.
Thank you.
13.
All right.
You talk to me.
Bill, and then McLeod. What's the state feels appropriate on this matter?
Yes, Your Honor. So, with Mr. Bill, I'm not going to object to his OR. This was a close call in the state's view. However, I reviewed the case that he had a warrant for. It looks like he pled guilty and was also found in contempt in October of 2024 on a citation for camping on the Truckee, which is obviously kind of what was underlying here. Looks like he was referred to community court and never appeared there. I don't believe that community court is still operating. So unclear what Reno Municipal Court is going to do with him as far as their bail. And then the only other thing I show for him is a 2003 liquor violation for the Bureau of Indian Affairs in Carson, which doesn't really necessarily show a conviction. It just has an entry there for a liquor violation. So given that, no objection to an OR. Would ask for supervision and testing, given the controlled substance that was located here. And with that, I'd submit it.
Any objection?
No objections, Your Honor.
All right, he's released. I don't see any point in testing. There's no studies that show that it's effective unless we're gonna give him treatment. So OR, Washington County Pretrial Services Supervision of bail laws, make no court appearance January 13th at 9:30 a.m. So that's next court date. We'll see then McLeod and then Roman Gonzalez. All right, what's state foods program on this matter?
Yes, Your Honor. So with Ms. McLeod, we are asking for $5,000 bail, supervision, and testing for controlled substances. The defendant scores a pretty high score at 13 with 2 points for failure to appear. She has a non-extraditable warrant out of Henderson for failure to appear for possession of drug paraphernalia. Also appears to have a non-extraditable FTA warrant out of California for possession of a controlled substance from the Henderson was from 2020 and the California cases from 2021. Looking through her criminal history, she has 12 warrants for contempt and failure to appear between 2023 and 2025. She has history going back to 2013. She had a felony conviction for attempted burg. In that case, she had her probation revoked and she was sent to prison. Had a 2013 felony conviction. Sorry, the attempted burg was in 2011. In 2013, she had a felony conviction for trafficking in a controlled substance, was sentenced to prison. In 2020, she had a misdemeanor conviction for petty larceny, was ultimately revoked in 2025 after 8 orders to show causes. Again, concerning criminal history, lengthy issues with substance abuse and an individual who as of late has not complied with court conditions, not appeared when she should. And so given that history, the risk to continue drug use and not appear, we believe that bail is appropriate with conditions and would ask the impose. Thank you.
All right, defense.
Thank you, Your Honor. Given the history of failure to comply, the defense agrees that some monetary bail would be appropriate in this case. We ask that Your Honor impose an amount that this individual can afford. So we would ask for $2,000 bondable with a 10% cash option. We were able to contact this individual's reference. She has a stable home. She lives at 7 Reservation Road at the Reno Sparks Indian Colony. She's lived her whole life there, and so she has strong ties to our community. Her reference also confirmed for us that she is currently employed. She has been working at the Bonanza as a prep cook for the last month or so. Her and her girlfriend, who is her reference, they do live together there on Reservation Road, and they do share a phone. So she does have a phone. She has a place to return to, and with monetary bail she can afford, she can be adequately supervised, and will have some skin in the game, as it were, to comply with her court hearings. Additionally, Your Honor, this is a diversion mandatory charge, as well as along with some misdemeanors. So a small amount of bail with conditions would be appropriate in this case.
All right, thank you. I think it's a very reasonable request. However, there are no peer-reviewed studies that show that an individual posting bail does anything to reduce the risk that they'll fail to appear or commit new crimes. The only purpose of bail is to hold individuals where there are no least restrictive means to ensure the safety of the community and the appearance of the defendant. That is the case before me, that I find by clear and convincing evidence. So the bail will be set at $10,000. However, I will release her to treatment at a level recommended by an evaluation, because I think that is a least restrictive means that would be effective. Again, there's no studies that drug testing reduce risk, but treatment combined with drug testing, we know not only pretrial, but in post-adjudication will reduce the risk the defendant poses. Bail laws make a court appearances. Check in with Washington County Pretrial Services as ordered January 9th and 9:30 is defendant's next court date. Thank you.
Explain to you what it means.
Roman Gonzalez.
So, Your Honor, in this case, we are asking to continue this matter until tomorrow.
All right, any objection?
Sorry, Your Honor, what, can I get the full name again?
Chris
Oh.
Roman Gonzalez. He's in on
Yes, Your Honor, I,
75,000 bail right now.
yes, Your Honor, no objection to continue.
Not your
All right,
turn.
see you tomorrow. Anybody else over the chair?
That's a